2. Okay,
Great, thank
we're
you.
good to go.
So David, both Toby and I were talking about how much we liked your program this morning. I just thought that was just excellent.
Good. Oh, I'm so glad. It really that's just so great to hear that. There are 3 more of those. So more where that came from.
I'll be there.
I'm signed up for all of them. Yeah.
Yeah.
Well, tell you what, why don't we've got some sort of basic stuff we've got to go through here. So do we, by the way, Mimi, do we know, do we have any public folks on this thing or?
Oh, well, before we get started, so we now have a quorum and we'll begin the meeting. This meeting is being recorded, and with the permission of the chair or co-chairs, I will start with the roll call.
Sounds good. I assume that's fine with Becky too. Go for it.
All right, Thomas Green.
Yep, here.
Becky Sandifer.
Present.
Marta Alkenbrock.
Here.
David Engstrom.
I'm here.
Thomas Green.
Yep, I'll still here.
Kevin Moore. Toby Rothschild.
Here.
And Patricia Scutiero. Okay, thank you.
Great. And do we have any public comment, folks?
So for anybody who would like to give public comment, can you please use the raise hand function? And when I call your name, you'll be given 2 minutes to speak. So I guess we'll start with Jason Solomon. Jason, are you with us?
Can you hear me?
Yes.
Great.
Yeah, you're on.
Thanks so much. Jason Solomon, Executive Director of the Stanford Center on the Legal Profession. A brief comment about the scope of the Sandbox. As you know, as part of the Closing the Justice Gap working group, and a lot of the Justice Gap problem affects middle-class people and small businesses. And if we look at Utah, a lot of the likely solutions that are going to come into a Sandbox are from non-traditional legal service providers and or people who are offering new business models. These are likely to help consumers who can pay something. So that's middle class and small businesses. But the question remains how to help the very poorest among us, many of which may qualify for legal aid, but legal aid can only serve a very small percentage of them. Think of evictions as one example where this is a huge problem today in California. One promising idea that's been used in other states and particularly in other jurisdictions is to allow people who work at nonprofits like community health workers and social workers to provide information and even sometimes things that approach advice to people in these situations. And so the question is, or the suggestion is, to make clear that this is going to be included in the scope of the Sandbox. That is, that people could apply to the Sandbox for essentially some way of either getting an exemption or a narrowing of the scope of UPL in such circumstances. And then to also think about how to encourage people. These are nonprofits who are not likely to be trying to make money off this, but how to encourage them to enter the Sandbox so they can do this. Thanks so much.
Great. Thanks, Jason.
Thank you. Is there anybody else who would like to give public comment? You should indicate by raising your hand. Okay, we do not have any other speakers.
Great, thanks, Mimi. And do we don't have any announcements, do we? Or do we?
Randy?
I'll make one announcement, also suffice as a staff report. At yesterday's SAGE subcommittee, the Structure and Governance Enforcement Evaluation subcommittee, at the end of their meeting, they talked about a desire to put essentially a standing meeting on calendar. And if they needed to meet, then they would be satisfied that the notice requirements were met and that availability was generally settled in terms of vetting the date and time. And I think they coalesced around, I think it was like a Wednesday afternoon, possibly every month, or maybe not every single month, but every 5 weeks or so. And that is something that if this subcommittee felt that it would be helpful, as opposed to perhaps relying on the few subcommittee meetings that are sort of smattered about our master plan schedule. If you wanted to have something that you could expect sort of at a regular time frame, and if we need it, it will be there. If we don't need it, we would cancel it, and we can poll the members of the subcommittee, see what works, and put that in motion. Again, it helps with meeting the notice requirements. We noticed that the paraprofessional group has many subcommittees, and they have used this approach. They have a subcommittee agenda, for example, it says continued discussion of paraprofessional rules of professional conduct. And if they need it, that meeting has been noticed and it's ready to go. So I just want to give you a clue, a little insight as to what your comrades on the other subcommittee are strategizing.
That's very helpful. Why don't we, I mean, we're just getting together for the first time as a group. Why don't we talk about that question at the end? See if you guys want to do extra meetings, because I don't want to impose, but that makes sense to me. But, you know, it's a group decision, it seems to me. Anything else, Randy, you want to touch base on?
No, that's it for me.
Okay, great. So I think that brings us to kind of a broader discussion. And Becky and I are we're thinking about sort of divvying this up. I mean, our major interest today is to just get a sense of where you guys might be and what might be of particular interest to you in terms of what you'd like to work on and focus on and things of that nature. So we're thinking about just getting a sense of your personal interests in this area, firstly, and then secondly, your at least initial reactions to the task ahead. You know, what kind of entry criteria, what is your sense of what this might look like, and things of that nature. And then I would be interested in talking just very briefly about whether you have an interest in getting more information. For example, Toby and I sat in on this seminar that David honchoed earlier today. There were a couple of people I would love to have you hear from, but you know, we should probably think about whether there's some process by which we could appropriately, within the confines of Bagley-Keene, share information and suggest the extent to which we might want to hear from additional folks. So that was kind of my agenda. Becky, was there more that we wanted to cover today?
No, I think that those are the 3 points I have in my notes from us. So.
Okay, cool. So why don't we just go around the table? I don't want to put you guys terribly on the spot, but what are your major interests? And why don't I talk to Toby, because I Toby first because I know him actually. So Toby, what's your kind of focus? What's your general sense in this area? Toby, you need to turn on your,
Sorry about that.
You're welcome. Go ahead.
Given my background, my primary interest, and I think that the Utah folks said it very well when they talk about the overarching goal being to improve access to justice. That's part of our name. Single regulatory objective: ensure consumers have access to well-developed, high-quality, innovative, affordable, competitive market for legal services. So my goal is, my focus is, and I think our public speaker earlier made the point that we really need to focus on both the low end and the middle and small business end of the scale of needs to be done. I have less concern about creating options for the big four accounting firms to have legal departments that provide legal services and other things like that. I'm really focused on what was my historic clients that I spent 50 years representing in terms of low income folks, but also the middle income and small business folks as well.
Great. Okay. Well said. And while you have the floor, I'm curious, in this program we sat in on this morning together, there was a discussion about how creative some of the legal aid groups were in terms of using technology and things like that. Can you just riff on that just a bit? I mean, you probably have personal experience with this, right?
Some. I haven't been as involved with it as a lot of others in the community, but Yeah, the Legal Services Corporation started 10, 12 years ago funding technology innovation grants and coming up with creative ways to expand access using technology. Some of them were pretty obvious, online intake systems, remote interviewing to reach out to rural areas, some of those kind of things. More and more now they're getting into more sort of practice areas and creating. I think the person who was my co-vice chair on the Adults Task Force created a program that helps people direct to consumer, basically helps people who transgender folks who want to do a gender change on their birth certificate. And it had created the foreign systems to do that. So that's one example of the kind of things that are going on.
Okay, I think we should try and explore that more, but that's very helpful. So how about Marta? Do you want to just give us a word or two on your preliminary thoughts?
Well, I've made a career out of representing lawyers, so that is my focus, and I'm a certified legal specialist, and so I'm really curious about the intersection between the rules of professional conduct and any changes to those rules with respect to access to justice type programs that we're going to be examining. So I think, that's my overarching interest and goal in this committee. I hope that suffices.
Oh, no, that's perfect.
Okay.
And good to have your expertise on this thing. You are a wonderful resource. So
Can I just follow up a little bit?
Yeah, please, yeah.
Can I just follow up a little bit? So as a non-lawyer and somebody who is not steeped in the California rules that you're talking about, could you just give some examples or a bit of substance for a total outsider?
Historically, the California rules of professional conduct have always prohibited fee sharing agreements unless there's certain parameters that are met. And certainly there's been historically no fee sharing agreements with non-lawyers. That has been the law forever. So, proposed changes to those rules, I'm curious about and interested in, and trying to see how that would, the nexus between any rule changes and what we're trying to do here.
Thanks.
Mm-hmm.
Terrific. All right. And then, David, I'm thinking I kind of know what the answer is, but what is your personal interest?
Well, I'm glad you think you know what the answer is. I don't really. I'm still sort of getting my feet wet on all of this. So, but let me just lay out a couple of thoughts. I mean, it seems like if we're gonna think about scope, then there's the question of do we and how much do we want to try to think about stimulating innovation within distinct segments of the legal services industry. And so that's what I think Jason Solomon said right at the start. He was making a plea to think about how we can try to spur innovation within a particular part of the legal services industry. At the conference this morning that I ran at Stanford, there's lots of talk of how you might slice and dice the legal services industry. There's obviously big law, which serves corporate interests, and there's Main Street law, which is middle class folks, largely small businesses, and then there's the legal aid segment. And each of these segments of the legal services industry face different types of innovation challenges. Some feel the pinch of lawyer regulation more. Some feel the pinch of lack of access to capital more than others. And I thought that was a very nice takeaway from the proceedings this morning. And so I think that's an interesting question for us. Like, we to what extent should we as a committee recommend a system that picks winners and losers, as opposed to, and I know Crispin put forward a submission that's in materials for today, where he basically says you shouldn't try to pick winners and losers. You should just let 100 or 1,000 flowers bloom and see what happens. And so I do think there's this question about whether we want to pick winners and losers, whether we want to try to shape the sectors of the legal services industry that benefit most from this kind of a deregulatory effort, the sandbox that is. And that's a tough question for this group, because both it's objectively hard. I think if you're, if you have your social planner hat on, it's you have to decide where the need is greatest and where this kind of an effort might promote the most innovation. Those are all really hard empirical questions. But there's also a political dimension to it, and that's something I wonder about whether we should stray into as a group. If you do pick winners and losers, that can create headwinds very quickly for this sort of an effort. So I don't know. That's my effort initially at thinking about what I think one of the primary questions is in front of us, which is that shaping question. I'm also interested in a second distinct set of questions, and this is something, Tom, that you and I have talked about a little bit, which is the data question. So if you look at the sandbox in Utah, it's pretty small scale. It's what you might expect in a relatively small legal market like Utah. There's certainly some nice entrants and some nice innovation that's going on, but the scale of it is not that great. And as a result, the data demands and the kind of analytic demands aren't that great. Like if you want to try to gauge harm to consumers, you can kind of eyeball a list of representations that have been concluded by one of the entities admitted into the sandbox. And so it's a fairly straightforward assessment process, I think. Now that could change. What thing that interests me is that, California is a much bigger place. It is a much bigger legal market. And this kind of a deregulatory initiative, the setting up of a sandbox, could attract a lot more business, could attract a lot more throughput of the system. And so I think there are really interesting data questions to think about. It could be that we're thinking if we want to propose a structure that puts some conditions upon entrance of turning over some data, it could be that there's much greater data flow than there was in Utah. And then at the back end, there's much more in the way of data analytics necessary to actually make and draw good inferences about whether there's consumer harm or not. And it just might be that we're looking at a very different kind of scale of data operations. And we need to think hard about data infrastructure and what kinds of data demands we would make on the front end, to make that data analysis at the back end as effective as possible. The last data piece, just as long as I'm on the topic, is the cybersecurity question and the privacy question. And the question would be, would we want to condition entrance into the sandbox on some assurances about data protection or privacy, or would we rather rely on some extant statutory regimes that are out there? In California, most notably the California Consumer Privacy Act, the CCPA. So I think that's another question for us to think hard about, whether we even want to get into the business of thinking about data privacy, or whether we want to leave that up to other parts of the regulatory ecosystem.
Yeah, it strikes me that part of that could be disclosures. I mean, one of the things that struck me, I think, about Arizona was, they were willing to tell people that the attorney-client privilege might not apply, but if you're a civilian, you have no idea what that means. So maybe a CCPA kind of disclosure regime of some kind, at least disclosures explaining what's going to happen, makes sense. But points well taken. Absolutely fascinating. And then you also are an expert on sort of algorithms and legal tech, right? I mean, that's part of your focus at Stanford, correct?
Yeah, that's right. So over the last couple of years, I've started to move into that space and have learned how machine learning works. I'm a PhD political scientist, so I have some quantitative training. And so that's allowed me to switch over and to understand machine learning far better. So I suppose I could provide at least some judgment, or at least do some work in thinking about, I don't know, how effective some of the tech tools might be, or as the topic of the conference this morning at Stanford was the innovation ecosystem, and part of that was how far and fast can legal tech go, which is to say, how fast can natural language processing, which is the branch of machine learning that is going to power these legal tech tools. That we have a legal system that trades in text. So the part of machine learning that analyzes text is obviously the part of machine learning that's going to be most important. And so that's another issue. To what extent, as we think about scope, do we need to try as best we can, even though it raises a bunch of $1 million and $1 billion questions, to what extent should we try to think about what that the arc of that technological development looks like over the near to medium term.
Yeah. No, I think that's a great point. Okay, great. So, Kevin, you want to say a word or two? I mean, I one of the legendary folks of bar service. What's your thinking on this one? Did I lose him?
Kevin Moore, I don't think he's joined us yet. I don't see
Okay,
him.
great. All right. How about Patricia? Any preliminary thoughts? What are your interests? What's your focus?
Hello. Hi.
Hi.
So, my interests are, I've made a list of them. So before I tell you my interests, I just wanted to make a suggestion that because these minutes and deliberations are for public consumption, that maybe we should spell out some of the acronyms, like what UPL is, or provide a glossary at the end, just so that people have
That's a great idea.
yeah.
Oh, that's a terrific idea.
Thank you. And so my main interest is access to supporting underprivileged people, so undereducated immigrants, non-native speakers. I want to echo the sentiments of Jason, who is a public speaker, who was talking about having like perhaps access for nonprofits to just familiarize themselves and within the scope of their field to be able to provide some guidance without actually giving legal advice, but providing guidance for people and to make sure that this platform, the logistics behind the platform, that it's designed that can be 508 compliant with the American Disabilities Act. So people who have like, you know, I don't know what level, but, you know, there are people that might use the platform as lawyers or whatever consumers who have visual deficiencies or what have you. And I would like them to also have an equal opportunity to access this platform. And then overall scope of just regulatory oversight and access. So when we were talking about the consumer protection, whatever we need to do to get the message out to people so that they understand whether or not their privacy rights will be maintained, or if there is a level of risk for that, they really do need to know what those risks are. Those are my main concerns.
Okay, that's very thoughtful. Thank you. And great idea on the glossary thing. I think that's very helpful. And then I think, Becky, do you want to chat a bit about your interests? And it's rare that one gets a MacArthur Fellow on a call like this. So what's your focus?
So my interest in this is in access to justice, and I'll completely disclose that the way I think about this is that what California is exploring is changing two kinds of rules. Some of them are about who can make money from the practice of law, and some of them are about who can participate in the practice of law. And I think that both of those are important, and this group needs to think about how to scope them. But if you're thinking about access to justice, who can make money off the practice of law is probably going to move the needle less than who is able to participate in the practice of law. And so I want to, my effort will usually be to keep that issue on the table. So that would be allowing into the sandbox certain kinds of activities that currently would be prohibited by the rules that say only lawyers can do certain things, like give people legal advice.
Great. Well, I think that leaves me, I think.
Kevin has also joined us too, just so you know.
Oh, Kevin, we're going around the table just in terms of your interest in this area. So, you know, big thoughts, small thoughts within, and welcome, by the way. Go ahead.
Okay, thank you. I apologize for being late.
Oh, no
I
worries.
just got a vaccination, so
Congratulations.
it took a little longer than anticipated, but
Yeah.
so it goes. Okay, my main thing is access to justice, of course, protection of the public, protection of prospective clients. One thing that always struck me from being on the ADLS task force was the pie charts that were used and showed how the wedge, the pie wedge, or the piece of pie that went to people law was shrinking between, what was it, 2005 and 2012. And I've only heard, so far, I've only heard what Becky had to say, and I kind of agree with her. I'd like to see an increase in the participation, because I don't think if we move that pie chart at all and increase the access for people law, we will have failed in whatever we do, whatever we come up with. I see, I mean, all the articles I read in the legal journals, not that I have access to a lot of them, but I've been trying to read and I've been trying to pick up on it. Everyone's focusing on what law firms, big law, is going to do with these changes that we might make. And I think that's the first point that Becky made about who can make money from the practice of law, how that can change. And that's not what I think we should be particularly concerned with. I really would like to see somehow, and I'm not sure how to do it. I'm a little bit skeptical sometimes about how we can encourage what's going to happen and get more people involved in providing the types of services where we see the greatest need from the justice gap study here in California. So I'm pretty open for ideas, and perhaps I can offer some ideas as we get a little bit farther along in the process.
Great. Thanks, Kevin. Well said. So as to me, I think my general sense of this is there is a huge gap. I mean, I can come at this by way of the litigation section of the CLA. So we part of our training programs are to young lawyers who don't have that much experience, and they are having a hard time getting jobs. And there is a supply sitting there waiting to be used, and then there's this honking big demand. I mean, there's middle class folks, there are poor people, there are some small businesses that are badly in need of help. So I think we do have a gap. I think we obviously need to do something about it. I think at the end of the day, so at least conceptually, I think we need to think about what this looks like if it actually happens 2 to 5 years from now. And I think what we want to be able to show people is we need to make it possible so that people can demonstrate, in firms or individuals can demonstrate that they're both effective and safe, that we're not going to do any harm to anybody if they come in. Beyond that, I'm not sure I'm really concerned. If they want to do it in an X way versus a Y way, that's certainly fine with me. But I think on an ongoing basis, we need to be able to monitor them so that we can make sure that they're both safe and effective. So at the end of the day, we can say this model worked, let them out of the sandbox and let them become part of the general population of the California economy. So, but I think this harks back to Toby. I want something that's efficient, competent, and effective, and that needs to be demonstrated. But so those are my preliminary thoughts. But Becky, do you want to go back and sort of get a bit more granular in terms of scope and things of that nature, or what do you think?
Well, so I think since I'm all about full disclosure, when we sort of first were handed the task by the broader group, it seemed to me it would be helpful to have a conversation about what the task is, right, before we try to do it. And so I think that one thing that's been really helpful is hearing the interest that people bring in and the issues that are front of mind to them now. Our task is to start to come up with a list of issues that, when we're thinking about the scope of the sandbox, what are the issues that we need to grapple with? And some of those have clearly come up in this conversation. So the question would be, as we've been listening to each other and thinking about our own responses to Tom's question, are there things that have come up for us that we want to make sure are on the table when we as a subcommittee and then the broader group are thinking about the scope of the sandbox's activities? So what kinds of things would be in, what would be eligible, that kind of thing. And like a good core classroom instructor, I've induced silence.
This is when you call on people, Becky.
Becky, this is Randy. Let me just make one observation in reviewing some of the materials that were distributed. One of the exercises we have in discussing scope is saying, well, this might be inside the sandbox, while this might be outside. And so, one way of deciding that is to say, well, if it's unauthorized practice of law, which stands in the acronym UPL, then that should be in the sandbox. But if it's not, then it should be outside. But I can imagine that there could be an applicant to a California sandbox who is envisioning a multifunction online service portal for consumers, where it could involve both delivery of legal services, legal advice, if you will, using some new delivery system, maybe technology, a chat bot, some sort, but also includes some of the more traditional, what I call law-related or non-legal service, such as, very detailed legal information and perhaps form or document production and drafting. And I'm just wondering, maybe from you or for the group as a whole, if an applicant was proposing something as a whole that offered a bundle of activities and services, but not all of them needed suspension or exemption from existing prohibitions, would we entertain that as a project that is being accepted for quote unquote in the sandbox? Or would we have to parse them out in terms of, well, you can already do your legal information and your document stuff. We only want to focus on this new legal advice technology. And I'm just curious, because I do think that if we're talking about innovation in a sustainable way, I don't think you'd have new delivery systems that are only one or the other. I think they could be bundled together. I mean, lawyer referral service activity, legal matching, it's a good example of something that might be paired with some technology-driven fixed fee or limited scope delivery system.
So let me see if I can pose what you've given a great example of as a general question. How much of the traditional practice of law does this group want to touch, right? And so when an entity comes in that combines the traditional practice of law with other stuff, where would this regulator fall down on the division between the traditional practice and the other stuff? I'll tell you what Utah does, which is not necessarily the right thing. We say the bar regulates lawyers and we regulate the weird stuff. And so then when you're reporting information about your activities as an entity that's approved in the sandbox, you only report non-traditional services if there's no ownership issue. Now, if it's say majority non-lawyer ownership, but you still have partially the practice of law, then the entity itself, because of who makes money off the work, is in the sandbox, even though a chunk of that is traditional legal practice. But Randy's absolutely right. That's one thing this system will have to figure out. Because who wants to double regulate lawyers? I mean.
Yeah, I think just to throw this out, I think, for that kind of a question, I think it would be mostly, well, there'd be various issues. One would be, does this thing serve an underrepresented, underserved group? I think that's still going to be at least my principal focus. The charging document is potentially broader than that. But, that would be certainly the question I would ask first. Who gets served by this? Secondly, I think since this is under the aegis of the bar and the Supreme Court of California, it's the law part of it. I mean, do we care if they do accounting? I mean, if somehow there is a conflict created between how they make their money on the accounting or the investment side versus the law side, I suppose there are some questions there. But I think mostly we're worried about legal issues myself. But to the extent that they're inextricably bound together, then that may require a broader view. But Kevin, Toby, I know you guys have thought about these things perhaps more than some of the rest of us. Do you have perspectives on that?
Kevin, you want to start with that?
I'll defer to you, Toby, on this. to be
Toby,
perfectly
hand off.
honest.
I tried to hand it off and he wouldn't take it.
Right.
Yeah, I saw that. Yeah.
You know, I think that, to my thought, Utah probably has it about right, that to the extent that it's practice of law within this entity, whatever the entity is, that the bar can and should take care of that. But to the extent that it's doing some other stuff that's not currently permitted to lawyers, I would say, yeah, it ought to get approval and be within the sandbox and all of the data collection and regulation that goes with whatever that ends up being. In terms of the multidisciplinary kind of thing, I think it gets back to the question of who's paying and what they're paying for and how that the money gets distributed. So if the legal side of it is independent in the sense of the money that comes in for the lawyers goes to the lawyers and the money that comes in for the accounting work goes to the accountants, that's one thing. If there's a general fee sharing of the work, then I think it needs to be in the sandbox because that's not permitted now. It's not something that would be allowed.
Okay.
I had something else, but I don't remember what it was now. So.
Okay.
So
Further thoughts on that?
Well, so I want to bring up an issue that actually came up in something that Tom said, which is, to what extent do we want to place as a table on as an issue on the table for the group to consider whether part of what defines eligibility is some kind of argument an entity can make about who it will serve? I'm not saying we wouldn't decide that today, but like, is this something we should be thinking through, or?
I can share my thoughts on that. I think that's definitely ought to be there. I think that it's likely that we will have a limited amount of resources. I can't imagine that this program will be able to undertake all of the possible areas that are considered within, you know, the huge market of California, all the people who would like to do something. And so I think that that's one way that we can make a decision on narrowing the scope of it to what we can reasonably, what the regulatory body, whatever it's going to be, can reasonably handle. And that would be my focus of it, is that it's what the unfortunate use at the meeting this morning, at the training, at David's training, where one of the speakers talked about the services in the penthouse and in the outhouse, referring to the high-end business, the legal aid sector. And I took a little offense at that.
It was a pretty pungent statement, though, I thought. Yeah, go ahead.
This, by the way, is Ben Barton, who has spent his entire career in that outhouse trying to serve people. So I
know that. Yeah.
He was allowed to be a little tongue-in-cheek there.
Yeah. He seemed like a lovely person, by the way.
Yeah.
Okay. All right. So further thoughts on that? I mean, one way of thinking about this is, you know, let 1,000 blossoms bloom, and, you know, if Big Four accounting firm wants to serve Chevron, good to go, or at least should be considered as part of this process. So is there a constituency for that? What do you think? I mean, I'm kind of thinking I'm more into the Main Street.
So I have a question. Sorry.
Go ahead.
So if we're thinking about fees, the fees and the commitment and the conflict of interest, or the potential conflict of interest and conflict of commitment for accessing this platform, how would that be monitored, and what mechanisms will we have in place? That's something that I would be concerned with, because if we do have larger entities accessing it, which can be like, we can have a spectrum of larger versus smaller nonprofits, but then how are we monitoring that, those COI, the conflict of interest and conflict of commitments and profitability?
Yeah, actually, I think that's a really interesting and big question, because it's, it strikes me that there are two possible, very broad ways of thinking about this. Is you let a bunch of folks try, into the sandbox. They do their thing. If we get some complaints, then we kind of react to them, or the bar does. Another is we let some in with at least some basis that we think they're going to be successful and be effective. And then we monitor them. I mean, I think I fall in we need to monitor them so we can show 2 to 4 years from now that they've done a good job or not, or if there were risks or issues that should be addressed with changes in the rules. But I think that's a big question. How intrusive at a high level, or how much oversight do we think is appropriate? And that would start with presumably these entry criteria. You got to agree to ABC kinds of conditions in terms of participation, I suppose. But
one of the other things that occurs following up on Patricia's comment is that it's not just the conflicts issue, it's confidentiality and some of the other rules as well. I'm thinking if you're merging with combining with an accounting practice, they have disclosure obligations to the SEC and to others that lawyers can't do. And it's not just at the high end, even if it's a nonprofit that does, social work and things like that. If they're doing social work and they run across in conjunction with the law firm, the legal side, but they run into an elder abuse or child abuse kind of situation where they're mandatory reporters,
that's
and
interesting.
lawyers can't be. Now, in some states, lawyers are, and I know that, but I think Utah is one of them actually. But here they're not, and so that's an issue as well.
Mm-hmm. Yeah. Okay.
Just
Yeah. In this general regard, I'll forward this to Randy so he can forward it out, but to the rest of us. But David shared with me a really interesting article on the lawyers and the lawyer-client privilege and the duty of confidentiality.
Mm-hmm.
And as soon as it becomes a mixed bag, it becomes very unclear what those rules are. So that may, at least from my perspective, at least in the way of disclosure, we got to explain to people what the deal is, because it's just as different as you get in more of a mixed sort of situation.
And Tom, when you say mixed, you mean where there's an automated component to it?
Well, automated, or you've got accountants, you've got social workers, like that.
Well, and even if it's a paralegal that's engaging, or a paraprofessional or somebody else that's engaging in what would be traditionally a lawyer's job, are they required to have duties of confidentiality and loyalty and those kinds of things that are traditionally an attorney's duty, not necessarily a paralegal's duty or a paraprofessional's duty who's not a lawyer? Mm-hmm. Those things have to be examined. And, one of the things that I was just kind of listening to the comments, if the overarching goal is to increase access to justice, then, I was struck by the gentleman from Utah who was describing the last time we were all together, kind of the one of the applicants into the sandbox that they let in was a gentleman who, I think he was a sole practitioner, maybe a bankruptcy lawyer, but I might not be remembering it. But he wanted his longtime, I think it was a paralegal, or somebody was a non-lawyer, to have ownership interest in the firm. And I thought that was interesting. But again, I don't know how that, and maybe I just, we didn't have a back and forth on it, but I don't understand how that increase in access to justice, if that's the overarching goal, how does that scenario increase access to justice for people for ordinary folks in Utah that want to file for bankruptcy or need some help? I don't know, but I was curious about those kinds of things.
Yeah, no, I think at least for me, I think it's a great question. I mean, I think, and David and Becky can speak to this probably more articulately than I, but there is a thought that one of the reasons that law firms don't, or lawyers don't use as much technology as possibly they should is that they're undercapitalized. So if there was non-lawyer money, like you could put your law firm on the stock exchange, or the accountants would be co-owners, or, I don't know, Goldman Sachs would be an investor in your firm, then that would increase technology, which would then in turn potentially increase services. I mean, that's a long series of, that chain gets a little long and a little odd at various spots, but I think that's one of the thoughts. And David, to you, I mean, you can probably speak to this more directly and possibly with an actual example.
Well, there was a lot of discussion this morning at the conference about what has happened in the UK, because the UK liberalizes lawyer regulation quite a bit in 2008, I guess, when it finally goes into place.
Yeah.
And that has for sure had a visible effect on the types of organizations that provide legal services. So it has permitted the creation of multidisciplinary organizations that frankly just aren't allowed under the American system of legal regulation. The interesting takeaway from this morning, though, was that that hasn't necessarily unlocked tons of capital, that if you actually try to get some kind of a back of the envelope sense of what the capital investment has been or that has followed that liberalization, it's actually not as impressive as you might think. And I guess two of the authors this morning from the conference were suggesting that the speed bump, the barrier to more innovation, certainly within big law, has been organizational. It's that it's actually hard to draw human capital. It's hard to incorporate legal technologists into teams run by lawyers. It's hard to provide career advancement tracks for pure technologists as they come into these newly crafted entities that are largely run by lawyers, and that's actually been the problem. So there is this really interesting question about, this morning we talked about three kinds of constraints. There are capital constraints. To what extent can service providers who want to and who have a great idea on how to deliver legal services, to what extent do they tap the capital that they need? To what extent are they subject to regulatory constraints, be it UPL or the ban on non-lawyer ownership or on fee splitting? And then there's the technical limits. The technical limits are, again, natural language processing, and those might hit hardest within people law, not in big law, because in people law, you have this translational problem. You always need a human in the loop. NLP isn't good enough to actually explain its outputs and its outcomes just yet. And so it's really hard to scale legal services, especially within Main Street law, was one of the propositions in the conference this morning. Anyway, I'm sort of babbling at this point, but there are three different types of constraints, and all those constraints bind in different ways depending on which segment of the legal services industry we're talking about. And I think that's, I thought that was one of the more interesting takeaways for us. Now, if you're running a sandbox, the strongest lever you have are to relax the regulatory constraints.
Yeah.
And so then there's a really interesting set of, call them empirical questions about, once you do that, does that unlock capital? And the answer might be it unlocks capital in some parts of the legal services industry, but not in others. And there are always going to be differences across the segments that we should be aware of.
Yeah, and I think, keep me honest here, David, but I thought one of those authors suggested that the amount of capital, at least in big law in the United States, was actually larger than it was in the United Kingdom. That they were investing, we in the US were investing more in tech than they were. But
yeah, that's right. And I think that's a little counterintuitive. You have this liberalization in the UK, and the point is to unlock capital, and yet it's not obvious that it's created huge amounts of capital flow in the UK relative to in the US. I think that was the point. Now Ben Barton, the gentleman who used the term outhouse, he talked about lawyer regulation and where regulatory constraints tend to bind most strongly within the United States. And his view, at least, was that they tend not to bind at all in big law. You know, big law has for a long time used paralegals in ways that might violate UPL, the unauthorized practice of law rules. But nobody complains because the corporate clients actually like the cheaper services that they get. And so that isn't the sort of regulatory complaint that's likely to make its way into a bar complaint system. Similarly, that's at the penthouse. Similarly, at the outhouse level, regulatory constraints are not thought to be that significant, and at least that's what one of the speakers said. And the reason is that once again, you don't have a ready source of complaints to make it an issue in front of in front of bar regulators. Your clients, they're massive information asymmetries, and your clients are, the disadvantaged who don't have the ability to complain. So where are regulatory constraints strongest? Maybe in Main Street law, maybe in that part of the legal system that serves middle class folks, maybe working class folks, and small businesses. And that's where you often get aggrieved lawyers who turn in other lawyers. And that's where the regulatory constraints are at their strongest and most binding. So I'm embarrassed to be saying all of this because, of course, like Becky has done, I spent a career thinking about these things. And for all I know, I just did serious violence to how lawyer regulation really does or doesn't work, or really does or doesn't bind within different segments of the legal services industry. But that was my effort to provide some kind of a faithful accounting of what I heard this morning at the conference.
Perfect. Let's turn it back to Becky because she really is an expert on this. But then I'd like to go to Toby. I don't want to be unfair to you, Toby. But if you were drawing on a white piece of paper, what might you put on the table for entry criteria? So think about that. Becky, over to you.
No, I think that David is absolutely right. And I would just amplify one part of what he said about the constraints on what we're now calling Main Street law in this group. It isn't just that ordinary people can't get access to services. It's that lawyers will, I'll give you an example that's now public, and so I can say it out loud. In Chicago, there was a workers' rights group that was doing wage justice stuff. And it ran its own little workshops with non-lawyers telling people how to file complaints with the state labor board. And so somebody went to one of these workshops and successfully filed their complaint. And so the employer hired a lawyer, which the employer is of course entitled to do. And the lawyer did two things. It defended the employer before the state labor board, fine. And then it filed a UPL complaint, an unauthorized practice of law complaint, with the state's disciplinary commission. And that's not just this guy loses his wages. It's that this group of disempowered actors in the world has now lost a mechanism through which it can organize around its own interests. And so thinking about those impacts, as well as just the sort of personal service impacts, I think is important when we're thinking about what regulations allow and what they constrain.
Okay, great. So Toby, what do you think? White piece of paper, you ticked off about 5 criteria for what should happen here. What might that look like as a scope of Sandbox kind of a question?
You're muted, Toby.
Yeah, I got it. Add one thing first to the last couple of comments, and that is that, yes, at the high end, they have used paralegals in ways that might not comply with the unauthorized practice rules. I think at the low end as well, for many years in legal aid programs, we've had paralegals that represent clients at administrative hearings with no lawyer involvement, whether it's a Social Security hearing or a welfare hearing. And they can be very successful at doing that. And a lot of those things technically don't require, if it's welfare or Social Security, they don't require lawyers under the federal rules, but unemployment hearings do, and many of the other administrative proceedings. But that's been going on for 50 years that I know of. But in terms of what I would put on that white piece of paper, that's a good question. I'd want to look at how is this proposal going to increase? I'm looking at our title, Closing the Justice Gap. How is it going to increase access to justice for anybody? I mean, if it's somehow going to improve access to justice for Chevron, then I would not automatically exclude it. But I can't imagine that that's a serious issue that we're going to face. But I would want to see what's it going to do to provide more services to more people. And as I say, my particular end is the low middle end, but I would include the middle class and small business in that as well.
And would you put any conditions that would be, that's your first question, is who are they serving? And what are your next questions, if any?
The next question would be, how is it going to provide something different than what's already there legally? And there's a lot of things out there that probably aren't within the current rules that are out there that probably could expand access legally. The traffic bots that are out there and things like that. I think that expands access to justice. But I don't know that repeating something that's already going on legally would, number one, would need to be in the sandbox, and number two, would add anything to closing that gap. There's a couple, and then I'd want to, once you get that, then you look at how effectively it's going to do that, and how it's going to ensure the quality and affordability and the like, to make sure that it's in fact improving the way things go.
And any questions about things like confidentiality, privacy? Are there questions for you in that kind of space?
There is, but I guess I'm thinking that I'm wondering if that's the other committee that's looking at the regulatory side of it, as opposed to the scope side. I think that's a whole issue that I care a lot about, is conflicts of interest, confidentiality, the other ethical standards, and how those are dealt with or avoided. But I'm not sure that that's a scope question as much as it's a implementation question.
Okay. So if there were, pick a conflict, pick a confidentiality issue, would you want to get a sense before you let them into the sandbox if they had those issues or not? Or would you wait till the regulatory process, whatever it looks like, began?
I would make sure that whatever the regulatory process is, which I think is what the other group is supposed to be doing, that includes, before they actually get into the sandbox, that there's a review of not just is it in the scope, but also how are they going to meet the regulatory requirements, which includes the ethical issues. And mention was made of ADA and Americans with Disability Act issues. I would also include language access issues in that, particularly in California. But all of those are things, I think, once you're within the scope. I see the scope as sort of a first cut to define what can come in, and then the rest of it is, once it, if it wants to get in, what else does it have to do within that scope?
Okay. All right, that's a great point.
Tom?
Yeah, please go ahead.
Could we talk?
Oh, and then to Marta. Yeah, Kevin, then Marta. Go, Kevin.
Okay. Could we get a little more concrete in what we're talking about? And
go for it.
I'd just like to give an example of why you bring up confidentiality, privacy, conflicts, competence. That's kind of my bailiwick. That's what I'm really concerned about. And I'm not sure it's just the concern of the other group, Sage, I think it's a scope in Sage or whatever, Parsley, and so on. But anyway, how about just use an example? I remember this came up with the MDP discussions in the late 1990s, early 2000s. Would you allow in the sandbox, say, an insurance company that wants to purchase an interest in a, I don't know, personal injury firm that could end up on the other side suing that very, a person who is insured by that insurance company? Is that
That's
something
your
that,
eyeball. Yeah, go ahead.
is that something we should be concerned about? I mean, I'm just trying to think, if we start thinking of examples, we might have a better sense of what type of scope we want to have. I mean, what we, something that is an obvious conflict. Is that something that we really want to permit? I mean, do we really need to see whether that's going to work out? If nothing else, the optics are going to be horrible in terms of
Yeah,
anyone
no.
before we even go into it. So,
Understood. Let me ask you two related questions. So firstly, should we be thinking about saying as an admission criteria, you got to comply with the California lawyer rules with respect to conflicts, confidentiality, et cetera. That's the A. The B would be, if we do that, what, if any, impact might that have on people being willing to sign up for our experiment? I mean, I'm kind of agnostic on, I mean, I do have an answer, but go for it. What do you think?
well, I think our confidentiality, I mean, the argument we've always made on confidentiality is, California, our lawyers here, we practice confidentiality and we honor privilege the old-fashioned way.
Mhm.
The only exception we have is death or substantial bodily harm. We don't
Yeah.
have the 7 or 8 exceptions that you find in the ABA model rules, or that you find sprinkled throughout the other jurisdictions. So that's something that attracts people. But on the other hand, do you want to preclude the possibility that some folks would be willing to retain someone to provide them with legal advice with less than all the protections that they might be afforded by a
Mhm.
lawyer? I mean, I wouldn't say incompetence. I think that whatever the services that are being provided, they need to be competent. But as far as the confidentiality or privilege, some people might be willing to do it. On the other hand, I still think that, as I remember some of our ADLS discussions where people said, well, we just leave it up to the client and the client can always give their informed consent. Problem I have with that is, how informed is the consent going to be? It's really going to depend. The consent is informed only to the degree the disclosure has been sufficient. And I'm not sure how we can ensure that the disclosure is going to be sufficient unless, I'm not sure how we track that. I mean, in terms of somebody is going to make that decision that they're willing to waive any confidentiality under those circumstances. So it's sort of like a roundabout way of answering your question. Yes, I would like to see those protections available, even if a non-lawyer is providing legal advice. On the other hand, maybe there is an avenue where people are willing to get less if they're going to pay less. Maybe they would be
Yeah.
satisfied with that. So,
Okay. All right. And how about do you have any thoughts on how big a picket fence we can erect and still have people come in and join this sandbox and do this experiment in California?
well, I don't mind making the application process somewhat difficult. I mean, I just was vaccinated, but when I signed up, I had to go through 7 or 8 different pages, web pages, answering questions
Yeah.
before I could move on and uploading information. So I really wanted to get it vaccinated. So yeah, I was willing to do it. I mean, I didn't consider it a burden. I mean, I consider putting a DVD in a DVD player a burden these days. It's an inconvenience, but I'd rather just, hit the button and stream something on Netflix or Amazon. But as far as if something is, I really want to do that, I think this is a good idea. I don't think it's a problem to make it somewhat difficult to do your gatekeeping function at the entry stage. I think we have to do that to a certain extent, and I'm not too concerned about that. If people are really interested in doing that, they have a good idea. I mean, on the other hand, we're going to have to keep our ears open and welcome the people who are applying, and evaluate their ideas in good faith. They may have some pretty good ideas, and maybe we can lessen some of the restrictions. But it's going to be, I think, a learning process, and I hope we can learn before we actually implement all this. We can learn a good deal from Utah.
Yeah, no, I hear you. Back to, let me just pose again the blank piece of paper question. What else would you add to Toby's list of things that's on that blank piece of paper? I mean, you've already spoken very articulately to competence, confidentiality, no conflicts, that kind of stuff.
Yeah, I think that's nice. I think a suggestion was made earlier about some commitment to providing services to those populations that have the greatest need, where the justice gap is the greatest right now. And I don't think that is either you do this or you don't get in, but I think we need to address if we're going to serve perhaps other populations, because people have to make money. And that was a big question I raised in ADLS. Where's the money? So that somebody is going to want to become involved in this. So sure, you're going to be serving those populations with the greatest need who might not be able to afford that much, but that doesn't mean you solely have to serve those types of populations. Should we be thinking, and I'm just throwing this out as a question, that a percentage of the business, not necessarily measured by the income that's being earned by the entity, but a percentage in terms of the number of legal matters where they're actually serving clients, might be required, or a commitment to do that. And for continued registration, they might have to demonstrate that they have actually honored that commitment over the course of several years.
Sort of, if you're building a condo, you got to have 3 units that are low income or something, sort of a deal.
Yeah.
Okay. So I think, Toby, any thoughts on that? Then I think I need to go back to Marta, but go ahead.
Yeah, I just want to add to that another way of looking at that is a preference. Is you get bonus points if your focus is at that closing the gap kind of thing. But it wouldn't necessarily have to be required, but you'd have a better chance of getting through if you did that.
Oh, okay.
I just want to point out that Donna and David have their hands raised as well.
Yeah, okay. Did I recognize Marta earlier? I'm sorry.
Yes.
Okay.
Yeah, but I think my comment, I was just kind of piggyback off of Kevin briefly. The example of an insurance company buying or having an ownership interest in a personal injury firm doesn't seem like it's increasing access to justice, in the sense that personal injury plaintiffs typically, they get they can have a lawyer represent them at no cost, typically, if it's a contingency fee arrangement. So, again, I think if that's our goal, we have to be mindful of that. And the one thing that I was also kind of querying is, in this scope analysis, is kind of diving deep into the areas where, family law or housing, debt collection, those kinds of things, where it's clear that there's a gap. Kind of honing in certain areas of law, it could be a part of this group's focus as opposed to a general categories, more specific into certain areas of law where people may need help that they're not getting now.
So sort of focused on the civil Gideon kind of high profile areas like those, I mean, family law, et cetera. Okay, great. And then I do see, why don't we start with Donna and then go to David. Donna?
And I apologize, I missed the first half hour or so, you may have already gone over this.
Donna, at least for me, I'm having a hard time hearing you. Yeah.
Sorry about that. My Zoom defaults to a very low audio setting, and I don't know why.
Now you're loud booming voice. You're perfect. Go ahead.
So I missed the first half hour of the meeting today. I apologize for that, and so stop me if you've already gone over this. But when I was looking at the materials that are posted online for the meeting, I think at least 2 of the 3 of you who submitted comments really sort of made the point of warning us to stay away from being too prescriptive in setting up the requirements for entry. We need to set the goals. What is it that we're trying to achieve? But we don't know what all the innovative ideas are that people are going to come up with. And so, if we set the goals of this is what we're trying to achieve, and you have to demonstrate how you're doing that, and what we're trying to achieve, right? We know we're guided by dual goals of increasing access and ensuring protection of the public. And so putting some real refinements onto that. But I would like to ensure that we think about that approach that was recommended in 2 of those 3 comments to really focus on here are the things that we're trying to accomplish. You're the innovator, you come up with a proposal and we'll consider it and see if it meets those needs and how well it achieves those needs. And as Toby said, maybe you get bonus points in that determination for something if we've got limited ability to let people in. But it was really resonating with me as I was reading those submissions from the group, and I encourage us to continue to sort of think in that manner.
Okay, let me just push you just a tad here. So if quality is part of what we want, some minimum level of quality, what do you think? I mean, they make a representation that this is going to be the greatest thing since sliced bread, or it's going to be a high quality thing. Can we ask them questions about how they're going to achieve that? Can we look at the algorithms they want to use? Does that become overly burdensome, or is that part of we need to assure some level of minimum quality as well as access? So
Yeah.
what do you think?
Great question. So, and that's right. That's certainly a logical admission criteria for us, that it's quality. And so, yeah, I would absolutely think, and sort of building on what Kevin said, burdensome doesn't so much bother me in terms of having to meet strict admissions requirements to make sure that we are letting people in who are seeking to achieve the important goals that we set. And so, yeah, in the vision I have in my head, I would think that would be entirely appropriate for the regulatory body who's considering the application to say, well, you can't just say it's high quality. You need to demonstrate that what you're going to be providing is high quality. And they make the person who's proposing the idea, may give their sort of explanation of how they're demonstrating that it's quality. And it may be that they will say that, in the first, 6 months, we'll receive 1 complaint and no more than that, so, or here's the algorithm, or, and letting them explain how they can demonstrate going in that this is quality service, or that they'll pull the plug if it proves not to be, sort of, but giving them some freedom to suggest that it's quality. And then the regulator can look at it and say, I don't think you've met that hurdle yet. So I need more information on how we think you're going to achieve this entry requirement of ensuring that you're providing quality services.
Okay, let me ask you a slightly unfair and hard question. What what's your sense of what does quality mean? I mean, somebody comes in and says, I've got this kind of cool set of algorithms that'll help you, I don't know, write a will. What's quality mean to us, and that could that mean to us in that context? Same as a lawyer, same as what, you know, I can imagine all kinds of things.
It's another great question, and it's something that I'd say that they're batting around a little bit in the paraprofessional working group as well. On the one hand, you may be talking about access to legal services for individuals who have absolutely no access today. And so, right, there is, and Becky's reading my mind, or I'm reading hers, quality could be, right, something is better than what you've got access to today. And if what you have access to is really nothing, then something better than that is helpful, and that's providing you better ability to participate in the legal system and to protect your rights. You know, is it going to be, you know, the same that you would get at a white shoe law firm? No. And so I think that we do need to think about those options of, you know, look at the access that you would have now, and is this providing you better information? I know that the legal services community, for example, has voiced some concern that, you know, if inadequate services are provided for people who, for example, meet their income criteria, they're going to have the job at the back end to clean up the mess, right? And they're concerned about these are people who, if they came to our doors, we could have provided them with quality services. They didn't. They got less than high quality service, and now there is a problem that we need to undo. And so that's, you know, that's a legitimate concern that, you know, the legal services community has expressed in the concept of the paraprofessional working group, and it's certainly something that we can keep in the back of our minds.
Yeah, cool. Thank you. That was a very thoughtful answer. Cool. So I think I see David, and then I think Toby, I think you're raising your hand, but David, why don't I go to you?
Great. So I wanted to try my hand at the, you know, the white piece of paper.
Oh, the white piece of paper? Go for it.
Yeah. So and I should preface it by saying that you know, what if we wanted to be super prescriptive here? What if, contrary to what Donna just said, contrary to what some of the submissions said, I think I've already referenced Crispin Passmore's submission in this regard. What if we wanted to be hyper prescriptive? What if we wanted to lay down a set of rules on the front end about who is eligible in the first instance to come into the sandbox? What would some of the dimensions be? What would some of the design parameters be? And I'll trot through a bunch of them, not because I think that we should adopt or recommend adoption of some or all of them, but rather just because I think it might be a useful enterprise to think about how we might try to cabin this, you know, this sandbox. So one design dimension is who is served. That's something we've been talking about a lot. So it could just be that we want only folks who are going to provide services to underserved groups. Could be everyone, including corporate, literally anyone. We don't care who's being served, but maybe we would want everyone but corporate. So we want kind of the legal aid groups to be able to come into the sandbox. Maybe we want Main Street law folks to come into the sandbox, but not corporate serving folks to come into the sandbox. Anyway, that's one design dimension. You could also imagine something like what Kevin noted, which is, you know, maybe there has to be some kind of a showing that at least some underserved groups are going to be served. All right, that's one possible. If we're going to be hyper prescriptive on the front end and really cabin who can come into this, that's one way to do it. Another way to do it is who serves, not who is served, but who serves. So you could imagine, I mean, one thing that's already come up is, do we only allow, you know, folks who are licensed to practice law in California, or do we allow folks who are licensed to practice law elsewhere? Like that's certainly a way to slice and dice who, you know, who serves. You can imagine nonprofits versus for-profit entities. So maybe we'd only want to let nonprofit entities in. Who knows? I mean, that would be the strongest form of what Becky was suggesting, where we want to, you know, we want to push toward, you know, people who can, the question of who can participate in the practice of law, not who can make money in the practice of law. So what else on who serves? Tech versus people. That's another slice and dice you could do. You know, do we want tech companies to come in? Do we want people companies to come in, or people to come in? Do we want to admit new types of practitioners, human practitioners in? there's a
Mhm.
one of the submissions notes that steps on the toes a little bit of the paraprofessional working group, but that's still a relevant dimension if we're thinking about this. Do we want to allow in paraprofessionals, alternative legal service providers, legal technicians, however you refer to them? Are they going to be part of the sandbox, or is this mostly a tech-oriented group? All right, that's two dimensions. Another dimension, the type of service that's being provided. If you're going to slice and dice, you could exclude and include certain things there. There's lawyer matching services and referrals. That's like, a lot of these are like the point in litigation time where the service is provided. So like referrals and attorney-client matching, that's way upstream. That's at the very beginning of a representation. You can imagine including that or excluding that. Legal advice. So, automated QA systems, chatbots, that sort of thing, or these alternative legal service providers that are human. Like that's another type of legal service that we could either include or exclude. There are a whole bunch of other, what are sometimes referred to as point solutions. That is like services that are provided within a particular litigation or within a representation, but they're only a piece of the sorts of representation or the sorts of legal services that somebody needs. Others, though, are like full-scale platform services. They're kind of soup to nuts. We provide, we in an automated way or with non-lawyer paraprofessionals, like provide you from cradle to grave legal services. Then there's a question of like live court representation. That's another point in litigation time. That's largely about alternative legal service providers and legal technicians and paraprofessionals, but do we let them into court? Like that's another possible way of slicing and dicing. Maybe we include that, maybe we exclude that. All right, coming to the end. You can imagine slicing and dicing based on the type of lawyer regulation that is relaxed. So unauthorized practice of law, Rule 5.5, that's certainly one thing you could relax, but maybe you wouldn't relax it. Maybe you would only relax the rules on fee splitting and non-lawyer ownership in Rule 5.4. Another way to slice and dice if we wanted to be hyper prescriptive at the front end and only allow in certain types of providers and certain types of services. Finally, maybe we want to like scope this based on areas of law. Maybe you want to include only certain types of legal representation or within certain legal silos, evictions, family law, consumer debt. That's another way to draw lines and to try to cabin the scope of this thing. You could admit everyone, which is what I take Crispin Passmore's submission to be, as long as they can make certain representations about quality. But maybe you actually use variegated requirements and variegated conditions. Maybe we're harder on the for-profit sector than we are on the not-for-profit sector, simply because the option for folks who are being served by the nonprofit sector is nothing, as Donna and Becky just noted. So you could imagine not slicing and dicing at the threshold for who can come in at all, but you could imagine slicing and dicing for purposes of thinking about how stringent we want the conditions to be. All right, that was my effort. I don't know if that was helpful or not, but that was like trying to sum up everything I've heard in the last hour.
Yeah, no, that was very helpful.
And if we were going to just put forward a whole bunch of Byzantine rules for who can come into this thing, like those, to my mind, are the relevant dimensions. And maybe that helps us to see, whether there are options there or whether we need to think about different ways to try to scope the sandbox.
Okay, let me ask you the hard question, which is, okay, I've got this scroll of menu options. David, what would you favor? What are the five criteria you would think would be important?
I have absolutely no idea. I'm just going to fess up. I have no idea. Like that was my effort to spur a conversation. I think almost every single one of those dimensions has all sorts of things and questions and empirics baked into it. And not only that, but there's the bigger question of whether a kind of ex ante rule approach is the right way to go at all. And whether instead, we should want representations about quality and ensure that the SAGE group has put in great monitoring and policing provisions so that we can be sure that those representations are actually adhered to once the services are already being provided. But I barely even have priors about a lot of those dimensions. It would be a little weird. I guess I could strike a few of them. It would be odd to like relax fee splitting and a non-lawyer ownership bars, but not UPL. But maybe I'm wrong about that. I think I tend to think about You know, a lot of those things can kind of work in tandem, and so it would be strange to pick and choose among those. You know, areas of law is a little odd, because maybe that's an artificial notion of the kinds of legal services that people need. People don't often come with like a single legal problem. You know, it's often that they've got, you know, mounting debt because of a healthcare problem, and, you know, people you know, and that's produced a bunch of problems and legal needs. And you know, as Becky has written so compellingly over time, most people can't even articulate what their legal needs are, precisely because of the fact that they're non-lawyers. And so it would be odd to try to slice and dice based on legal claim or legal silo, just because, you know, we know that people who are in trouble, who have unmet legal needs, often have multiple legal needs, and it would be odd to, you know, to exclude, you know, some types of legal needs rather than others. So maybe I'll just stop talking there, but my broader point is just to plead ignorance and say I don't know, but I hope that was like a useful slice and dice exercise.
Okay, and then let me turn to Patricia. You've asked this sort of interesting question in chat. Patricia?
Oh, sorry. No, I was just taking notes because he gave such great information. David, I took notes on everything you said because of the different categories and I'll never remember it. So I just put it in the chat, but thank you for calling on me. Yeah.
Okay, very, very cool. So anybody else want to be heard? Andrew has his hand up. Wait a minute, let me just check again. Andrew, why don't you go ahead and say a few words?
Thanks, Tom. I just hearing the conversation, especially David's very helpful list, brings to the question for me, you know, what is it that you wish for the Sandbox to do? So ADLS, as I understand it, and Toby and Kevin can correct me if I'm wrong, and I don't think this group is stuck with this proposition, but I think ADL's recommendation was use the Sandbox to test these rules and regulations for an ability to evaluate whether permanent changes can be relaxed later. And if that's the goal, then I would think a wider ability for more applicants to come into the Sandbox would be best, for the reasons Donna was saying, and to allow a better testing of partnering and ownership with non-lawyers, sharing legal fees, whatever it is that we want to test. You'd want to be less prescriptive, because you wouldn't get a good sample. The sample size would be limited, and that might not be as informative. Another approach, I'm not sure if this is what Utah's doing, but there's a way to quote unquote exit the Sandbox. You come in, you're seen as a safe actor, and then you're going to be allowed to participate in perpetuity in the market because you've been evaluated and you're deemed safe. And we're not going to overly regulate or monitor you as we did when you were within the Sandbox. You're now deemed with the good housekeeping, quality of approval, and you can go into society. So I don't have an answer as to what the Sandbox is going to do, but I'm not sure that this group or the other subcommittee has really come to terms with what the Sandbox is going to do. If it's only 2 years and we're going to be overly prescriptive, how effective might some of those services be? It might take a year for a company to develop their program or platform or technology. And so if the Sandbox is only open for 2 years, it takes you a year to develop, you apply, it takes a month or 2 months to get reviewed, then you're only in the market for 10 or 8 months. And how effective is the evaluation there? So I know there's a lot to get our arms around with, and I'm not trying to add more, but I wonder if a threshold question is, what do we want the Sandbox to do? That might inform what we think the scope should look like.
Yeah, I think, at least for me, I think it's a place for people to demonstrate the fact that they provide service to people we care about, define that, and they do it in a quality way. So that's what, a Sandbox is a test bed. So you need to sort of see what works and what doesn't. But in any case, but the time thing is interesting. Becky and I were talking about that because, if you are a new entrant, 2 years is really very little time to demonstrate. You've got to advertise, you've got to hire staff, you got to do all this stuff. So if you were a venture capitalist hearing a presentation from a legal tech company, what would you want to hear in terms of time? 2 years is unlikely to be the figure you're looking at. But that I think it's a very serious question. But
Can I just pull up one thing for the group that I think that maybe is a rephrasing of something I heard Andrew say, which is, if this is a place where we're road testing something, what's the thing that we're road testing? Are we road testing specific innovations to see if we're cool with them? Or are we road testing bigger changes in the way we regulate this stuff to see if the aggregate outcome of that is something we're okay with? And I think that is an important question for the group to settle on at some point.
Or is it both?
Right.
yeah, I mean, isn't it necessarily both? I mean, if these guys need waivers, isn't that a kind of a test? And then, somebody's got to design a regulatory process, which I think is something that, is not necessarily within our purview, but I would think that that's all regulatory reform from my perspective. But what do you think? I mean, back to you, Becky. What do you think?
Well, so what if half the majority non-lawyer owned entities seem nice to us and half of them seem terrible, and we can't tell what the difference is? Right, we can't tell what predicts whether they perform well or poorly by whatever it is we say is important to measure. Then that says the regulatory scheme is imprecise or spotty at achieving its goals, but it says that half those entities are awesome and half of them are terrible.
Well, I think, let me play that back to you, because I think I at least would not make that distinction. I mean, I think more it's a question of what is your service model? How are you going to make money? And does it yield a quality result? I mean, those are the metrics I think are most important here. And I think we need to be able to tease that information out so we can make those distinctions. Because if, half of the companies are failures, it's not helpful, I think, to this process.
So I would say absolutely politically it's not helpful to the process, but one way of thinking, I mean, I think this is another important issue. So one way of thinking about this, and it goes back to David's winners and losers observation. One way of thinking about this is that we're like a university research ethics board. And when I ran one, I said, I don't care how stupid your research is. I just want no one to get hurt when you do your stupid research, right? So even though it doesn't make any sense, it's got terrible design, that's your problem. My problem as the research regulator is preventing harm. And so if you're thinking about it from a consumer protection perspective, it doesn't matter if they have terrible business ideas. But if you're thinking about it from the viability of the sandbox and how the experiment looks and the also political elements of it, then maybe you want to think about whether they have successful, like most of them will live on through the experiment.
Yeah.
But then I think you'd also want to talk to people who will tell you the rate at which those kinds of experiments survive in non-new regulatory environments, right? So the rate at which new businesses and new ventures fail, which is pretty high. So that's all.
Yeah. I think mine, not to extend this dialogue, but that, it strikes me that at least preliminarily, I think the entry criteria is, are you likely to be able to provide a quality product? And obviously we can have discussions about what that means. And that's kind of the most important criteria, I think. After that, it's whatever structure you have, and let's take a look at what you got going. But in any case, so we're about 25 minutes from stop here. And Becky, who is one of our experts, Becky, do you want to just kind of take a little time here and talk about your perspectives on this? I
feel like I've talked a lot.
Okay.
But I also feel like this has been an incredibly productive discussion in terms of identifying the different questions that this group thinks the group has to work its way through. So. Yeah,
no, I think that's right. Because it strikes me, and this to you, Becky, initially, but I think that maybe what you and I need to do is to try and distill this down to, some major points, and with wobble on the ones that we've had very yeasty discussions on, and then maybe play this back, I guess, at the next meeting, which I guess is next Thursday or Friday, to the larger group.
I have a quick question for the staff. So if Tom,
yeah.
if Tom and I were efficient and prompt in turning around a draft of what we think this conversation said, are we able to share that with the subcommittee for input before the broader group meets, or do we have to wait till the broader group meets under rules about notice and stuff like that?
This is Randy. So we had sort of built that in terms of the hope that the co-chairs of each subcommittee could provide us with their agenda materials to post. And once it's posted, what we envisioned is that we would have a notice go out to all of the members of the entire working group. So there could be cross-pollination as well as the two
Sure.
silos working, and that we would have a deadline for emailed comments to staff, and we would collect a document similar to what was on the agenda materials for the subcommittee meeting for the larger group. And so the folks who have been listening on this subcommittee to everything that's being said, all the great comments, they'll see what Tom and Becky produces and gets posted. And then they can say, wow, they really put a great spin on it. And that inspires me to add this other comment that I think embellishes it even more. And they would send that into staff, and we would collect all of those, and they would be a tool for you to lead that presentation of that item when we're in the full group. And so
Okay.
the short answer is yes, you could get it back, but we don't think there's another time frame built in that would allow you to send a second version of what you did out to your subcommittee. I think by the time we get it and it's available for commentary, it's already up on the website for the meeting, but you can adjust your presentation of it based on what we get in.
Got it. Thank you.
So Becky and I, so it sounds like, keep me honest here, Becky and I can chat. We can try and summarize this. Obviously, everybody in this conversation will be at the next meeting. So we would say, okay, here are the 6 major takeaways. Here's where we had debate, and lay that on the table for the larger group. That's kind of the best way at this point.
Yes, and so both the subcommittee members present here, as well as, there might be someone on stage who has something, John Lund, someone else might want to contribute something very helpful after reading your materials, and that should also be in play when we get to the full meeting.
But don't we have a full meeting next week?
Yes, that's what we're aiming for.
Okay.
Yeah.
All right. All right. Well, Becky, shall we just commit ourselves to doing the best we can here in terms of summarizing this for the next meeting?
Yes, and we'll put, since you're a lawyer, you'll know how to write a disclaimer that says, summarizing this, but we make no representations as to its accuracy or whatever, whatever it is you guys do.
Disclaimers are us. Okay, good. So let's just go around the table again briefly, just to make sure anybody wants to say anything more. And then let's turn to this question of whether we want a regular meeting and when. So Marta, you're up. Anything else you want to add?
I think, Tom, your comments on quality, I think, are really interesting. And I think that obviously would be the goal. And, one of the concerns, and I know, here in California, there was a lot of press on, for example, people that were unlicensed helping out immigrants through the immigration courts. And a lot of them.
Oh, the notarios. Yeah.
Yeah. And that's, those people were robbed of thousands and thousands of dollars and got absolutely no help. I'd hate to see something, that, so emphasis on quality, there has to be something substantial that we can, that the Sandbox guarantees these people who are going to be entering, who are going to be hiring people for certain services, that make sure that they have something better than somebody who may have some knowledge of the immigration courts, but actually just rips them off. But that was my only comment.
No, that's a very thoughtful comment.
And then I guess a couple, in wrapping up, are there more materials that we can make that we can be circulated amongst the group, and especially the kind of the tech aspects? And David, I'd love to find out more about the program that you had this morning, and this, I think you mentioned that there's 2 more coming. If there's a way that we could get access to that, that would be great, because I'd love to do some more reading and some more homework.
Yeah, I
Because
think
I
that's
don't
a,
have enough of things to read in my profession.
yeah. I think the best thing to do is probably send it to, if you've got a document you want to share, there are these Bagley-Keene things which are a little challenging. So if you send it to Randy or Becky and myself, and we can send it to the staff, and then they can send it out, and there won't be any problems. And David, I thought you circulated everybody, but would you send your class thing to Randy, and then he can distribute it from there? Because this was, at least what Toby and I saw this morning, was really high quality, very interesting stuff.
Sure. I'm happy to do that. I sent out an email, I thought, to the whole group, and
You did too,
announcing
but
the conference and providing a link. And now I'm worried it went into some spam folders or something. But I can resend that. And the conference is for sure open to anyone. So
yeah, it's free. I mean, it really is good.
Easy to register and to show up. And I think I can say that the next 2 sessions, they're on Wednesday mornings at 9 a.m. Pacific. That worked best to incorporate East Coast people and international folks. They're presented this morning. There were 2 presenters from Oxford University, for instance. And so it's a kind of an odd time, but it'll be the next 3 Wednesdays. This coming Wednesday is about what I would call lawyer-driven legal tech, so tools used by lawyers to provide representation. And then the following week is going to be legal tech and access to justice. And we'll have a bunch of people presenting, including, among others, just to give you an example, Chief Justice McCormick from the Michigan Supreme Court, who's been very forward-leaning on access to justice issues throughout her career, but especially as a Chief Justice. So that gives you an example of the sorts of people who are presenting at the event. And so I encourage you to attend. There are things to read that we could recommend. I have a paper coming out soon that does what I think is a very serviceable overview of these lawyer-driven tools that, just to use the phrase I've used too often in this meeting, that tries to slice and dice the world of lawyer-driven legal tech. So that might be something. The best overall comprehensive report of legal tech for the unrepresented, so where a lawyer isn't holding the steering wheel and driving the tool, is Becky. Becky did a report on this, and maybe that's something we should circulate. So am I right about that, Becky? I mean, you have a very comprehensive report of, I think it's titled Legal Tech for the Unrepresented.
Legal tech for non-lawyers.
Oh, for non-lawyers. Okay, got it.
That was a huge report. Yeah, maybe. So David, if you would send your program announcement to Randy. Becky, if you'd send your report, fair warning, it's honking big, but it's really useful. And then David, could you also send
appendix? It's mostly appendix.
Okay. And then David, could you also send that interesting article you sent me, which was on the question of the duty of confidentiality, et cetera, and how that kind of disappears into the mists when you change the structure and reduce the number of lawyers and all that kind of stuff.
I can send that. And I will also send, though you didn't ask me to send it, I will also send that article of mine that I mentioned that talks about.
Yeah, perfect. Oh, I think that'd be outstanding, because the more we know, the better, I think.
Tom, can I ask David if there is an online link to an archive of this morning's session?
There will be. We recorded the session, so there will be, so folks could watch it. And that could be useful. This session was styled as a look at the innovation ecosystem. So it really was about what are the regulatory constraints, what are the capital constraints, and what are the organizational constraints that are going to determine the arc of the development of legal tech. And so that will be of interest to people. It'll talk a lot about different segments of the legal services industry, but I certainly don't want to scare people away from the future sessions, especially the one that's 2 Wednesdays from now. What is that? February 24th, which is on access to justice. And I think that will be a really interesting session for people as well. But to answer your question, Randy, yes, there will be soon enough like a video link. I think it'll be essentially a YouTube link, but a private YouTube link. So folks will have to have the link, which I can send to you when I get it. They'll have to have the link in order to be able to
Okay,
access.
send
the
it to me and I can
proceedings.
turn it around to the group.
Yeah, and
I-
one brief footnote on that. About an hour and 10 minutes into this conversation this morning, David raised the question about, well, there are these sandbox things. What do you think should happen there? So, I thought the discussion, it was about 10 minutes, but it's directly on point for us. It's really good. So anyway, I'm sorry.
Let me just mention one thing. When you guys are circulating anything, this is just a reminder. Can you please make sure you copy CC the ctjg@calbar.ca.gov. All communications should be have that on there, be copied to that email box as well. And also include Angela Marlowe. She's the one who will be circulating it to the subcommittees, all the material. She's your main point of contact. I also want to point out that, let me put it on the screen real quick. There is a CTJG OneDrive, and I can send you guys a link. I don't know if you can see my screen, but there's a, hold on, where'd it go? I lost it. Oh, it's right here.
Why don't you email it to us?
I'll send you guys a link. This is a public sharing folder. So if you guys wanted to upload your resources and documents and links to stuff, you can totally do it by going to one of these folders. For example, you guys would be Scope. So you would click on this and you can just go ahead and upload the documents you want to add for everyone to see. And it'll be there. So it's like a historical archive for you guys.
Okay. All right. Great. So we were going around the table.
Do you mind?
Marta. Yeah,
Sorry,
go
do
ahead.
you mind if I add to something that Marta mentioned? Since
Oh, please, yeah.
Okay,
Yeah.
great, thank you. And thank you, Marta, for mentioning the whole incident with the immigration scams. I'm going to call them scams, but because I myself I'm an immigrant, I've learned how to code, which coding means that I can switch off my South American accent to speak more Americanized when needed. But I understand that, like, having moved from different states and coming to California, I noticed that there is a large gap of non-native speakers who don't have access to the needs that they necessarily want, and the under education, like the access to education. And so when they are in a situation where they are looking for help, it could be someone who is a native speaker of that language who is also committing a scam against them. So I am very motivated with this platform to allow more people to have access to communicate to all. And I can see this progressing at some point to having a multilingual platform as well. So I'm really excited to join this group, and thank you for mentioning that. It takes a lot of courage for those people to have moved forward and actually spoken out about it too, if they don't have their status. It's a scary process.
Yeah. Oh yeah, for sure. So David, I think anything more in terms of closing thoughts here?
Take a page from Becky's book and just say, I've talked too much.
Okay.
I will rest.
All right. The gentleman from Stanford rests. Kevin, anything closing arguments you want to?
Nothing further to add. Thank you.
Okay, Toby, you get the last word.
One just quick point, and I would just to put it on the table and then from my perspective take it off, but I think it needs to be there if we're looking at what ADLS recommended to us. One of the issues that a lot of the people on ADLS, and I guess it's overall would be in their recommendations, was a very broad sandbox, as broad as possible. And one of the things they specifically were looking at is experiments that dealt with moving the boundaries of both the fee sharing and investment, the 5.4 issues, as well as the 5.5 unauthorized practice issues, and the advertising and solicitation issues, that all of those things would be on the table for people to propose as a way of knowing, are those regulations really doing any good? Do we really need them at all? Yeah. Or did Arizona have the right idea? So I would put that on the table. I'm not sure I would approve any of it, but I think if we're following our predecessors, I think it ought to be on the table.
Okay. Points well taken. Okay, let's turn to this question potentially of a regular meeting. Thoughts, folks? Are got 5 minutes to go here, so something once a month, potentially, a week or so before the meetings. I suppose if we did it like a week or so, but say week to 10 days before a regular meeting, since they're meeting every couple of months, that would be an extra meeting every couple of months. So thoughts, do you want to meet more frequently than that, or does that sound about right to you?
Just an
You don't need
observation.
another meeting? Yeah, go ahead.
Just an observation in case that sounds terrifying. This subcommittee is not eternal, so we have a deliverable and then
Yeah, we
we're
do.
released
Yeah.
to other tasks. So you wouldn't be committing to doing this forever.
So maybe like 2 or 3 extra meetings, maybe. No more. It's a guarantee. Subject to the usual disclaimers. But thoughts? Going once, going
Well,
twice.
I think the idea of, I would like to see a meeting maybe a week after the general meeting, so that we have a chance, while it's fresh in our mind, to take back the input that we got from the full group as we develop whatever our recommendations are going to be.
Okay.
And then if we need another one a week, 10 days before the general meeting to finalize whatever the next report, the piece of our report's going to be, I would be comfortable with that personally, but my schedule is probably not as busy as some of you.
Yeah, okay. Well, tell you what, why don't we do this? Do folks have strong feelings one way or t'other? Week after kind of works for me. And then we could sort of see if a week or 10 days before also works or is necessary. Any objections? Let me suggest a process. Why don't we, I know you can do these surveys of people's availability that are real easy breezy. Let us, Becky and I will have the staff send something out over like a 2 or 3 day period, see if people are available. We'll try and keep it to an hour, and we'll do at least initially the week to 10 days after the next meeting, and then we'll kind of take it from there, and we can discuss our feelings about next meeting after that. But let's assume we'll shoot for that unless there's objection.
One of the things that the other subcommittee did was that pretty much they threw out, since there's not very many of you on the subcommittee, just the days that don't work for them, whether some of the people teach on certain days of the week, or there's certain meetings, staff meetings that they can't avoid. If there's any of those, it'd be better if you guys told us now so we wouldn't even pitch those days. Just feel free to tell us what day. We were able to narrow it down to literally just one day of a week that people felt they were most open and available. Is there anybody who has certain days of the week that does not work for them at all?
For me, it's Tuesday.
Okay.
Yeah, this is Tom. I've got this crazy case I'm working on. So, Fridays are always my best day. I'm always pretty flexible.
Anybody have any other exclusionary dates?
Yeah, this is David. I mean, I teach Monday. Right now I teach Monday, Tuesday, and Thursday mornings. So if we can avoid that, that's actually helpful.
Okay.
But yeah, thanks. Sorry.
Yeah, ideally for me, it would be Fridays. I have a lot of meetings usually. Wednesdays are not that great, but it looks like Tuesdays don't work for others. So I can compromise. Wednesday afternoons are better.
Okay. All right. Anybody else have particularly good open days or terrible bad days? So the staff can suggest something. Going once. So Mimi, does that give you enough to work with?
Yeah, I think we'll start with pitching Fridays. And if it looks like there's not enough people to attend, then maybe an alternative would be maybe Wednesday afternoon. That sounds like that works for most people. But I mean, that'll be the alternative day. We'll see how it goes. We'll send out a poll and make sure that we have a quorum in order to proceed.
Okay, sounds good. All right, anybody, any further comments, suggestions? Becky, do you want to close us out?
Nice work, everybody. Thanks.
Yeah, we got a bunch of stuff on the table. Thank you all. Okay, great job.
All right. Take care, everybody.
Thanks, guys.
Bye-bye.
Okay, thank
Thanks,
you.
everyone.
Thank you.
Bye-bye.
Take care.